Welcome. My name is Adeline Frew, and I'm the Director of Appointments with the Northern Ireland Judicial Appointments Commission. NIJAC is currently recruiting medical members for the Review Tribunal, and the purpose of our session is to help inform potential applicants about the work and the rewards of the Tribunal. I'm delighted to be joined by Adeline Wilson, who is the chair of the Review Tribunal, a role she's held since 2015, having been a legal member since 2008. Adeline qualified as a solicitor in the Republic of Ireland and then in the North, and has had a very successful career with the Departmental Solicitor's Office. I'm also delighted to be joined by Jim Carson, who is an experienced member of the Review Tribunal, having had a very successful career as a social worker. Adeline, please, can I begin by asking you to tell us about the work and the role of the Tribunal?
Thank you very much, Adeline. If I could just maybe give a little bit of the background to the Review Tribunal. The Mental Health Review Tribunal was established under the Mental Health Northern Ireland Order 1986. And from that time until the commencement or the partial commencement of the Mental Capacity Act in 2019, it had a very discrete jurisdiction. Its jurisdiction was to consider the lawfulness of the detention of patients detained in hospital for medical treatment, to include those patients in hospital because they were transferred there through the criminal justice system, and also to review the lawfulness of persons detained under guardianship. That jurisdiction was extended when the Mental Capacity Act was partially introduced in 2019. And the Mental Capacity Act brought a number of changes to the tribunal. The first, I suppose, and the most obvious change is the change in name. The Mental Health Review Tribunal became the Review Tribunal. Its jurisdiction changed. It was extended to jurisdiction to consider the lawfulness of those deprived of their liberty in any setting, in circumstances where they lacked capacity in relation to their care arrangements. It also changed, in a way, the constitution of the tribunal, in that under the mental health order, the panels were always comprised of a psychiatrist, an experienced member, and a legal president. Under the Mental Capacity Act, the medical member of the panel does not have to have a background in psychiatry. They may be a generalist medical member. So that means instead of having a pool of 3 members, we now have generalist medical members, psychiatrists, experienced members, and legal members. Also, and very significantly, the workload of the tribunal has increased significantly, as indeed has the membership by reason of the Mental Capacity Act. There's a huge backlog of cases where people have been deprived of the liberty in nursing homes and care homes for many years, together with people who are just being transferred to nursing or care homes. The workload is substantial. It is very, very time consuming. Under the mental health order, we dealt with 1 case in an afternoon setting. Under the Mental Capacity Act, we are currently dealing with 4 cases per day, which involves preparation, consideration, and writing up decisions. So it is hard work, and it is very challenging work. And hopefully that gives you a flavour in a very summary manner of what we do on the tribunal.
Yeah. And what are the rewards of the tribunal as well as the challenges?
Well, the challenges of the tribunal, of course, are many and varied, as I've already said. And certainly one of the great challenges for me is the realization that in every case that we determine, whether it be a patient detained in hospital for medical treatment or a person deprived of their liberty in a care home, we are making a decision contrary to the opinion of the treating team or the caring team. And that's particularly significant for me in the mental health order cases, where if we decide to discharge a patient, we're doing so contrary to the advice of the treating team, and in particular the treating psychiatrist. And that is a very challenging and a very sobering thought. However, we're not there to second guess the expertise before us. We're there to apply the statutory test. And the statutory test is quite clear and is quite high. We have to be satisfied that the patient needs to be in hospital for care and treatment. For example, that the care and treatment cannot be provided in a less restrictive setting. And also that discharge of the patient would give rise to a risk of serious physical harm to either themselves or others. And that is a very high bar. Our decisions are informed, obviously, by the evidence we hear from the parties, which is generally provided to a very, very high standard, and also by case law as it has developed and as it continues to develop. So making the decision to discharge in either jurisdiction, I find very challenging. And it's also challenging to realise that in every case that we're involved in, we're dealing with very vulnerable people. We're dealing with their families, we're dealing with their lives, and we have an insight into their lives and to the very intimate details of their private lives. And it's a challenge to respect that and to respect them and their confidentiality and to understand their circumstances, their history, and make an informed decision. In mental capacity cases, I find them very challenging because, as I said, we can deal with up to 4 cases a day, many of which are very, very similar, many of which you have people who are suffering from dementia, and many of the symptoms are common, and there are similarities across the board. But in every case, you're dealing with a person, you're dealing with their loved ones, and you're dealing with their care and treatment and their best interests. And it is challenging just to consider every case on its individual merits. And it's also, of course, very sobering because dementia it doesn't discriminate, and it's always a source of great sadness to me that, you know, we read of lives well lived who are now lost to dementia. So it is a sobering and very challenging experience. But the challenges are there, there is no doubt about that, but it is also very rewarding work where we have a statutory purpose, and that is to safeguard people's human rights. That is an owner's responsibility, and it is rewarding work in that regard. I also find it very rewarding to work as part of a panel and to benefit from the expertise and the life experience of those others on the panel. Every member of the panel has an equal voice and they bring their experience, and it's always a learning experience for me. I can't believe when you say that I was appointed in 2008, time has really, really flown, but no later than this morning, I learned some very valuable information in relation to the registration of nursing homes and care homes that I wasn't aware of. And that really emphasizes to me the important contribution all 3 members of the panel make and how we really learn and respect each other's experience and contribution.
Yeah, excellent. Thank you. Fascinating. Jim, if you'd be kind enough to tell us something about your own background and what you get from doing the work on the Review Tribunal as an experienced member.
Thank you, Adeline. I am a retired social worker, having spent my whole career in social work in various settings. Towards the end of my career, I worked as an approved social worker, largely under the mental health order, and at times did have to present evidence and be cross-examined at tribunal. So in a way, I'm a bit of a poacher turned gamekeeper now that I'm sitting on the tribunal. As to why I applied, when I retired, I didn't want to keep working 5 days a week, and I wanted something flexible that would be interesting and rewarding, and I found the tribunal to be a very good fit for that. In terms of interesting, it allows me to use the skills and the knowledge and experience I've got over my career and from personal experience to analyse cases with the other members of the panel. And that's a key thing for me, because I always worked in multidisciplinary teams with other disciplines, other professions. And I find it always stimulating, interesting, and you always learn something when you're working with different disciplines. So I find it very stimulating and interesting to do that. In terms of the rewards, it's clear that it's very important work, in that this is an independent review of trust decisions to deprive individuals of their liberty and infringe their human rights. The MCA, the Mental Capacity Act, introduced in 2016, has greatly expanded that work. And now we are routinely reviewing cases of people in care homes, as well as those detained on the mental health order to hospital. So in terms of experience, I wouldn't be put off if you haven't worked as a healthcare professional or in an associated sort of voluntary organization over the course of your life, because everybody will have some experience of knowing somebody who is either deprived of their liberty or may well be at some point in their life. In 2018, there was over 4,000 dementia beds in Northern Ireland. That's 4,000 families and 4,000 individuals deprived of their liberty. And the tribunal is the way this is reviewed independently of the trust to make sure that it's proportionate and legal. So everybody will have some experience of this over the course of their life as the MCA rolls out and is embedded into the fabric of our society. One other thing I've noticed in terms of rewards, which I find very rewarding, is an example of a case study that we often get papers in front of us where it's clear that families have gone to endless lengths to try and maintain an elderly relative in the community. And inevitably, that takes its toll in terms of care stress. The person there's no other option but to admit the person to a care home to keep them safe. And it's clearly in their best interest, but that doesn't stop families feeling guilty about their relative being in a care home. And I suppose when the tribunal look over the case and make their judgment and send out a decision, the family get to see it in writing, that the tribunal are totally independent. They've reviewed the proportionality and the legality of it, and they feel that it's the right decision in terms of the person's best interests. So it assuages some of that guilt and also gives reassurance to the family, and also recognizes the endless lengths they've gone to over the course of the progression of the illness. So I find that very rewarding. And I suppose in summary, I could highly recommend anybody thinking of applying to the tribunal. I've thoroughly enjoyed working with the other panel members, and I think it's a great opportunity.
Jim, thank you. And I think you've again really emphasised, both of you have really emphasised the seriousness and the importance of just how important that this work is. I would like to take a little time to sort of highlight to potential applicants the range of resources that's available on the NIJAC website. So there are nature of the role documents, which are like companion pieces to job descriptions, which help give a bit more further insight to the work. There's also on the NIJAC website profiles of Jim and Attracta's colleagues, as well as even themselves, I think, perhaps their profiles on their background and what the work involves. And for this particular scheme, there's also a point of contact available who's not a member of the selection committee, who potential applicants can speak to on a confidential basis. All the information to do with that is available on the, in the applicant information booklet, and there'll also be details in that of how we ensure that the recruitment process is as COVID secure as possible. Applications for the medical member will close at 12 noon on Monday, the 13th of September. So good luck to all of those who apply. Attracta, have you any closing words for us?
Well, I would just echo what Jim has said. It is very rewarding work, and I would encourage people to apply. When I applied, I had no background, well, certainly no significant background in litigation or in mental health or in mental capacity, but I certainly had no expectation, to be honest, when I applied that I would be successful at interview. the application process is demanding in itself, but all of the disciplines that are represented on the tribunal have transferable skills. We all learn from each other. It is rewarding work. I would say do not be put off by the nature of the process. It is a stringent process because it has to be. I would encourage people to obviously read the application form. I would encourage people to read the criteria, to make contact with the point of contact so that they're making an informed decision. And there is an expectation that there will be a big response to this competition, as there is to all competitions run by NIJAC. So for those who do apply and are not successful, I would encourage them to look for feedback and encourage them to learn from their feedback and to apply again. We are very fortunate at the moment in that we have a very experienced cohort of members from a range of different backgrounds and a range of different experiences. And they all bring their own expertise and add their own value to the process. So just don't rule it out. Don't say, this is not for me, I could not do that. I think it's probably fair to say that many of us, certainly when I was appointed, I was very, very nervous, and I faced a steep learning curve. As Jim has already said, we learn every day. So I do believe the review tribunal is a very welcoming tribunal. We learn from each other. We provide training. We are always there to answer questions. We all recognize that we have made mistakes in the past and there are things we would perhaps do differently. That's human nature. The point is to learn from them and to share our experiences. So I would certainly echo what Jim has said, and please apply, and very good luck if you choose to do so.
Thank you so much. I think we'll end it there. Thank you.